Along with me is Reddy Neumann, my business partner. We are partners in Reddy Neumann PC. As every Tuesday, we bring in live immigration news. Emily?
Hi, my name is Emily Newman. I'm a partner with Reddy Neumann PC and also the writer behind the blog immigrationgirl.com. We're here today to talk about the latest immigration news that's going on. We practice solely in employment-based immigration areas, so we stay up with all the hot topics going on. We'll be discussing the latest USCIS memos, particularly on the NTAs, or notice to appear, as well as the most recent memo on denials without issuing a request for evidence, which happened last Friday. Do you have any updates for us on some of the common topics like the H-4 EAD for us today?
H-4 EAD, nothing new has been come up at this point of time, although we were expecting some new regulations based on the agenda published by the administration that they're going to come up with the proposed regulations in June. Please understand that it's a proposed regulations that are supposed to come up, but they have delayed until now. We don't know when they are going to issue the proposed regulations. But I think so there are other main important issues that we need to update our clients, particularly about the USCIS guidelines on denying the H-1Bs without an RFE or notice of intent to deny. Emily, I mean, 70% of the H-1Bs, we do get RFEs nowadays, don't we?
Yeah, I don't know if it'd be 70%, but certainly a large number, and I think that's related to the increased scrutiny on specialty occupation. What would have been approved easily before, now they're second guessing whether it actually requires a degree or not. More importantly, this is not just related to H-1Bs, this is for any kind of immigration application that involves status or some kind of benefit request. So it could be an H-1, an L-1, an
I-130,
EAD, I-130, 485. So interestingly, in the actual guidance memo, they list a few examples of situations where they might deny without an RFE, and their only examples are related to waivers and I can't even remember what the other one is.
Most of the things related to the family immigration,
right,
of I-130 and criminal waivers and other things. But anything about business immigration they touched. Why is that everybody's buzzing that it's going to be more about business immigration, though?
Right, because they didn't even mention it in the memo, but the guidance does apply to all types of applications. So what does this mean? Basically, if a petition or application is filed without certain required initial evidence, rather than replying back to the applicant with a request for evidence, asking them to provide that required initial evidence, now USCIS has the authority to just flat out deny the petition. So you really have to be aware of what is considered required initial evidence. Number one, this doesn't take effect until September 11th, so we do have actually some advance notice this time around. So we can start making plans now to make sure that all filings that happen after September 11th include all required initial evidence at the time of filing. Don't expect that you're going to get a chance to submit something later on if you don't have it at the time of filing. So for H-1B petitions, this is particularly all the required forms, the LCA, a description of the specialty occupation nature of the job, proof that the beneficiary H-1B worker qualifies for the job, proof of any licensure if the job requires a license, and an employment or agreement or contract is supposed to be required initial evidence. So all of those things should be submitted up front. No more providing documents later on or waiting to provide it later on. Now, does that mean there's going to be no RFEs issued at all? What do you think about that?
No, there will be RFEs issued. It's just that if there is a fundamental document, like Emily was telling about LCA, labor condition application, the degree certificate, if the degree is not in United States, an education evaluation is not there, there is a good chance that they might deny it with an RFE. But no, I don't think so. It's going to be every case that where they think that they need additional information, they're going to deny. Now, obviously, in the employment-based relationship, employment-based immigration, Emily, there are a lot of applications where we are unable to provide the documentation initially, especially when the person is working at a third-party location. the USCIS is asking, in the RFEs particularly, the end client letter, the vendor letter, the contract between end client and vendor, the contracts, the purchase orders, and all those things. Sometimes they're unable to provide that. In the basic guidelines of the essential documents that is required to adjudicate the H-1B, are these third-party placement documentation is an essential part of it or not?
I don't think we know yet. I think most likely not, because it's not listed as required initial evidence in the actual I-129 form instructions, and there's nothing in the regulations or the statute that require those documents. It's a separate guidance memo that asks third-party placement employers to provide those documents. So, going forward, starting September 11th, I would certainly submit as much as possible to avoid the situation of potentially getting a denial without ever having a chance to respond with additional documents.
What do you think is a probability that if after September 11th, that if you don't have certain documents that we normally respond to the RFE, like the end client letter, vendor letter, contract between end client and vendor, what are the probabilities the USCIS is going to deny the application without RFE?
I think it's too early to predict that right now. My guess is that they won't flat out deny. I do think they'll still issue RFEs for those because it's not listed as a required document, but we'll have to see. I mean, it's going to be up to the officer's discretion now, so we could end up with some bad denials like that.
There is a required document, what they have listed in the in the USCIS when we are filing the H-1B, Emily, in particularly the education evaluation when it's a foreign degree. Are there any other documents that are essential? You pointed at LCA, any other essential documents in there?
If the job requires a license to do that work, you have to provide the license now at the time of filing, as well as an employment agreement or contract or a summary of the oral agreement. Those are the required documents. And then if you're requesting an extension of stay or a change of status, you have to also provide your previous status documentation, such as your I-94, passport, pay stubs if you're extending your stay, and those types of documents are required initial evidence.
In light of the February 22nd memo, where they have clearly pointed out that they need to have these documents so that they can figure it out whether there is an employer-employee relationship exists, whether the position requires a specialty occupation. You are already aware of the February 22nd memo. Do you think so that if they will link this policy guidelines to that memo?
I think the door is open for that, because in the RFE policy guidance, it states that officers are to look at all existing policy guidelines, as well as the statute and the regulations and the form instructions, to determine what is required initial evidence. So we don't know yet whether that will be a requirement, but I think there's certainly a possibility they might be headed that direction.
The September 11th, you said, Emily, is the deadline that they have given, that in that particular, after September 11th, they're going to start denying, based on the guidelines, they might deny the cases without issuing an RFE or notice of intent to deny. Is that the September 11th? They started adjudicating the cases or deciding the cases, or is that if we file an application after September 11th, that rule is applicable?
Right. The good news in this memo is it does not take effect until September 11th and only on applications filed after September 11th. So if you've already filed, this memo does not apply to you, even if your application is still pending in September. This is only going forward for applications filed on or after September 11th.
Emily, there are a lot of things that are going on with the USCIS and this current administration. And I want to educate our audiences, and I want your response on those things. Effective September 11th is what we've discussed about the USCIS guidelines on denying the cases without issuing an RFE. Then there's another effective August 9th memo that dictates that F1 students unlawful status. And then we have July 5th, 2018 guidance on the notice to appear. We have April 19th, USCIS has changed the definition, changed the third-party placement on the STEM extension. On February 22nd, 2018, we have the USCIS memo with regards to third-party placement on the H-1B. Where do you think so this administration is getting? And how do you intend, being an immigration lawyer, do you intend to defend your clients and make sure they're properly in status?
Right. Yeah, I think it's clear it's an attack on legal immigration. The goal is to reduce the number of legal immigrants in the U.S. by denying cases without an RFE and then issuing a notice to appear, charging students with unlawful presence, making them subject to the 3-year bar. Just memo after memo is certainly headed in that direction. What can you do as an attorney? You know, my job is to make sure that I'm filing every application with all required documents, all I's dotted, all T's crossed, to make sure my client has the best chance of getting an approval without running afoul of any of these things. So I'm filing my extensions earlier than I would have before. I'm recommending premium processing so that you can get the decision before your I-94 expires. With this new NTA memo we talked about last week, just as a reminder, if you have a pending application and it is denied after your I-94 expires, USCIS officers now have the authority to issue an NTA, a notice to appear in removal proceedings. This starts the deportation process, and once that's issued, you can't leave the country until you've gotten permission or you've completed the removal process. So it can have a huge impact if a denial occurs after the I-94 expires. Therefore, I would file early to ensure the I-94 doesn't expire. Don't rely on this 240-day rule. Don't rely on this pending transfer, then filing another pending transfer.
Wait a minute, Emily. There is a rumor that says that premium processing is going to surely get denied. Is that true?
No, it is not. We have very good success with premium processing. I've never really found that there's a higher percentage of requests for evidence in premium versus regular. I think that people maybe use that as an excuse because they were going to get an RFE no matter what. If the case is going to get an RFE in premium, if you waited 3 months, you would have gotten that same RFE in regular processing. So why wait? Why delay the process and actually potentially put yourself out of status, unlawfully present, and in removal proceedings? It's just not worth it.
Addressing the issue in light of the new memo of the USCIS guidelines on this notice to appear, Emily, how dangerous is it? Is it like they're going to, every denial is going to now come with a notice to appear in the court? Or is it going to be discretionary to the USCIS officer? Have you seen any notice to appear recently for the cases where the change of status have occurred?
Right, so as of right now, I'm not aware of any notice to appear that's been issued after that memo came out in relation to a denial of an extension or a change of status. And unfortunately, we don't know exactly how they're going to implement it. We don't know if across the board, no matter what, no matter the circumstances, every single case that is denied after the I-94 expired will result in an NTA. I would assume that there are not enough attorneys, judges
for the USCIS,
for the removal proceedings to be able to handle the influx of all of those cases. So I'm hoping that they will limit this to more serious situations, maybe where there's some misrepresentation involved or some kind of bad act, but we don't know that. All we know is that officers have the authority to issue it anytime there's a denial and unlawful presence. We also don't know how long they're going to take to issue that NTA after the denial comes. Are they going to come together? I highly doubt it, because I think that the NTA is required to have certain information in it that a USCIS officer wouldn't quickly have access to put in the NTA to send it out with the denial. So my guess is they'll issue the denial, give you a chance to leave, and then if you don't leave, issue the NTA. That's my hope, is that that's the worst that is going to be, that they'll at least, I mean, these are professionals. I couldn't imagine if someone knocked on my door tomorrow and said, sorry, you need to leave the country, and I'm in the middle of a job, I've got kids in school, I've got car, I've got rent to pay, a mortgage to pay, whatever
Well,
it
if they
is.
can
and you're
separate
just,
a baby of 2 years old baby with a mom, Emily, they can do anything.
They certainly can, but I think they need to give a reasonable period of time in the event of a denial for someone to wrap up their affairs and exit the country before they go to the extent of issuing an NTA.
One thing, the Facebook Live, the questions are coming is that, what is a notice to appear? Once we get the notice to appear, what is the procedure for it? Notice to appear is requesting, the USCIS is requesting that you appear in front of a judge why you should not be removed from United States. In general, though, when the notice to appear comes in, you will have two options. One option is that the court date is already set up, or the court date is not set up. If the court date is not set up, you can hire a lawyer. The lawyer can negotiate a deal with the USCIS saying that my client is going to leave the country voluntarily without you removing out of the country. Most of the cases that in the employment-based immigration, if there is a notice to appear, will fall into this criteria where the USCIS immigration lawyers working for the immigration will allow you to leave the country. There are some cases that might come up where they might say that you have to appear at the court. So once the notice to appear comes in, you cannot just leave the country, because if you leave the country, you will be under removal proceedings and you will be considered to have been removed from the country, and that will trigger a lot of bars for you to come back into the United States at a later point of time. So once the notice to appear is been issued, you need to contact a lawyer, and the lawyer will negotiate a deal with the USCIS lawyer, and then with the permission of the USCIS, you're going to leave the country.
Robin has a good question. In the event that you have your pending extension, and while your extension is pending, your I-94 expires, if you leave before there's a decision on your extension, is there any chance of an NTA being issued?
I would not take that step right now of leaving the country before the I-94 expire.
Before the decision?
Before the decision, though.
Unless there's you've got a good indication that it's a weak case.
Yeah, I'm getting these calls in our daily conference calls, in the consultations. People are panicked right now. They don't want to go to the court and be in the removal proceeding, rather than leave the country, though, when the extension is pending. If you leave the country at this point of time, once you leave the country, they won't issue a notice to appear. But leaving the country while the extension is pending, though, at this point of time, I'm not sure it's advisable at this point of time. As Emily was pointing out before, that she has not seen a notice to appear recently in any of the cases that are involving the employment immigration denial at this point of time. We will educate you, we will inform you. Keep coming to our conference calls, to live, or you can even set up a consultation with us. We will inform you, but it's not necessary at this point of time for them to leave the country. I don't want to spread panic among the people, and then you just leave the country while the extension is pending, though.
Yeah, I think really it's important to just stay calm. If you've got a strong case, you shouldn't have anything to worry about. If you have a weak case, maybe consult with your attorney before you take any action. Maybe wait and see if there's a request for evidence issued, and if it seems like it might be difficult to overcome, then maybe a different answer would come out. But
right.
For now, I wouldn't take any different action just based on this memo coming out.
The panic is spread among the people that, okay, somebody's coming knocking the door, and then so that panic is creating these kind of questions, Emily. We have seen the little kids getting, put in different than their mothers, and that's creating panic among the people. Maybe that's the purpose of the administration. But at this point of time, in the employment-based immigration, we haven't seen any drastic NTAs that have been issued. We will educate you when the NTAs will be issued.
All right, so kind of talking about that with the NTAs and the unlawful presence memo for F1 students, are we still expecting that to come in August 9th?
Of course, we did comment it on the August 9th memo. We have recommended a lot of employers and employees to comment on it. Hopefully they commented on that. Yeah, August 9th memo seems to be that it's going to come in right now. And August 9th memo, what it tells is that previous to this memo, which may be effective on August 9th, we don't know yet, it might have some changes, but if it goes as effective as what they have drafted it, unlike before, I will compare what was before and what is going to be after August 9th if this memo comes into the picture. If the person is determined to be violating the F1 status, the day the USCIS decision comes in, they are considered to be unlawfully present in this country. Now, this memo tells that it's not the day that the USCIS issued the unlawful presence will count. It is the day the person violated the status. So, for example, if a person has taken a CPT after completing the OPT and STEM extension, and if the USCIS determines that the CPT is not properly done, it is not proper, and they deny the status because he took the CPT where he's not eligible to take the CPT, it goes back to the day the CPT started. And that's where the danger is. When does the unlawful status count? Is since it's counting going back to the CPT status and coming to down the line right now, if that period of time is more than 180 days, then the person is not eligible to apply for a visa status for the next 3 years. And if that violation of CPT or whatever the other violation USCIS alleges happened more than 360 days, then there is a 10-year bar on the person to come back into the United States. Now, previously, or right now, if the status has been denied, the unlawful state on the day the denial is been given. So the person has enough time to go outside the country to apply for the visa and maybe to come back into the United States. But since it's going back, then the 3-year or 10-year bar kicks into picture. Please note that the effective date of this memo is August 9th. So if the change of status or if the status has been denied, the undocumented stay will not go back to the CPT period as what's described. It's going to be from the August 9th of 2018. So, and then going back to 180 days, it's going to be February 4th or February 6th of 2019. Did I explain correctly, Emily?
Yes.
It's a very tough thing. It's a very tough thing to explain.
Right, yeah. So most importantly, if there's a determination that there was a violation of status, the earliest that the person can be considered unlawfully present is August 9th, the day this memo comes into play. So a lot of people, I think, are scared about this and wondering, if there's a potential issue with the F1 status by itself, am I going to be considered unlawfully present? Am I going to get an NTA? And I want to point out that the unlawful presence determination requires a decision from USCIS. So there's got to be a decision on a change of status or a decision on an OPT or a STEM extension or something like that. So they're not just going to come out of the blue and say, well, now all of a sudden you're violating your status, you're unlawfully present. There's got to be an actual decision on an application that you have filed.
Emily, now in light of these denials without RFE, in light of the notice to appear, in light of this memo with regards to 180 days and 360 days that we discussed about unlawful presence, what do you think about the STEM extension people who are working at the third-party site? As you already know that the USCIS website has been updated saying that the STEM extension people cannot work at third-party location.
Yeah, and I think that number one, can you make that change with just a simple website update? And number two, how do you implement that change for people who've already been approved and are already doing that? There has to be an effective date somewhere, and it should have been sometime in the future to give people a chance to comply. But just making this announcement that this is how it's going to be, and oh, by the way, this is how it was, you just didn't know it, and now we're seeing requests for evidence on H-1B petitions where there's a change of status request. asking about where the person was working during the STEM OPT. And whether we can overcome that, I think it's a little tough right now. I don't know if it's something that can easily be overcome in the H-1B adjudication process. I think it might be something that requires a separate lawsuit, probably.
Which is already filed yesterday.
Right. So we might see some action taken on that to avoid the difficulty that students might face who've already done the third-party placement while they're on their STEM OPT without knowing that it's a problem, because USCIS never said it was a problem until this year. And unfortunately, if you've already worked at a third-party site while on STEM OPT, the question then becomes, well, if I work in-house going forward, does that solve the problem? And there's not really a way to cure a status violation. Once you're out of status or you've violated your status, you can't just get back into status by working in-house. And so I think that for a lot of people who are getting this type of request for evidence, they may want to look into the option of changing their petition to consular process rather than requesting the change of status, in order to avoid getting the determination that there's been a violation, therefore avoiding the determination that you're unlawfully present, therefore avoiding an NTA. I think that that might be a prudent thing to do, given all of this guidance now.
I think so, that I would advise the audiences to discuss one-on-one with your lawyer to see if you actually can argue that I don't want to have the change of status, I just want to go to India to get the consular processing. There are two parts of the H-1B application normally USCIS rule says. One is whether your status is current. That will determine whether they're going to change the status from F1 to H-1B, and the other part is that H-1B where specialty occupation, control and other issues are there. Even though sometimes the USCIS denies the status, they still approve the H-1B application. They will approve it without the I-94. As Emily was pointing out, that maybe it's worth for you to speak to see if you have to go for consular processing, is where we are telling the USCIS, don't worry about the change of status. I'm going to go to India or whichever country you belong to, but I would like the H-1B to be approved without I-94. That is a possible consideration you might want to discuss with your lawyer privately, so that you can make determination on case-by-case basis.
All right, changing gears a little bit, are there any things to be concerned about in filing an H-1B transfer these days with all of these, with this new RFE memo? Does the RFE memo apply to transfers?
Why not? Yes,
exactly.
It does.
Does the NTA memo apply to transfers if your transfer is denied after your previous I-94 is expired?
Absolutely, it is applicable.
And so yes, transfers, if they're not properly filed with all the necessary documents, or are not able to successfully get the approval before the I-94 expires, or get denied after the I-94 expires, it could put you in a tough situation. So be careful with the company that you're transferring to. Make sure it's a good, solid company that is going to prepare the petition with all the proper documents so that you have the best chance of approval, and probably don't wait till the day before your status is going to expire to file your transfer. Make sure you give yourself enough time before your I-94 expires.
I want to go with common questions that pops up, Emily, is that we are noticing a little bit more denials than compared to 2016, 2017, a lot of H-1B denials, and that's making a lot of people go out of status, get into large trouble though. And you already know that the cap gap, where you file a H-1B before April, on April of 2018, and your OPT or STEM extension is expiring before October, you will be considered to be in a cap gap period. In that cap gap period, if you have filed for a change of status from F1 to H-1B, you can continue working until October. And then we're noticing that the denials are coming. Now, when the denial comes in, can they join another university if they're in the cap gap?
Well, I think that there's a problem with the SEVIS system that actually terminates the SEVIS record when the denial of the H-1B occurs. So what's supposed to happen is if the H-1B is denied before October 1st, you're supposed to be granted a 60-day grace period from the date of denial. And normally, during those 60 days, your options are to plan to depart the U.S., file a change of status to some other type of visa that you might qualify for, or enroll in a new program at school by getting a new I-20. That third option seems to be not as readily available anymore because the SEVIS system is kicking people out based on the H-1B denial, even though you have the 60-day grace period. And we're finding that when the school asks for a data fix to put the person back in the active status so that I-20 can be issued, the SEVP system is refusing to do so. And they're relying in part on part of the USCIS website that says that that 60-day grace period, the purpose of it is only to allow you to depart the U.S. Now that is actually contrary to the regulation for the F1 students that actually says the 60-day grace period can be used to prepare to depart or to transfer to a different school. However, it's a glitch in the system, it seems to be anyways, that's kicking people out, and now once you're out, you're out. So if you have any concern that your H-1B might be denied, maybe you've gotten a nasty RFE and you're not able to provide everything that's needed to respond to it, you might want to consider enrolling in a new program before the denial happens rather than waiting until after, if your plan is to ultimately continue your studies.
Emily, questions are coming in with regards to if the person has had a degree not in computer science but in other field, let's say mechanical engineering or chemical engineering or probably civil engineering, and he has been having H-1B in software field from past 10 years. He has gotten 2 transfers and 3 extensions, never any problem. Are you noticing any problems right now, and what is the solution for these people? They have their families, their houses here. What is the solution for those people who have degrees other than computer science?
Right, yeah, I think that there is a problem now, even though you've been approved multiple times before. USCIS is relying heavily on the Occupational Outlook Handbook that explains for software engineers the typical degree requirement is computer science. So anything not computer science, especially if it's more further away than maybe electrical engineering or something like that, but if you're talking civil engineering, mechanical, is not closely enough related to computer science to where they're questioning, are you qualified for this job that you've been working for the last 10 years? So what can you do to avoid that situation is when you're filing now, especially if you're filing after September 11th, to get an education plus experience evaluation and submit that at the time you're filing, showing that your education plus experience combined is equivalent to a degree in computer science. That would be the safest way to solve that problem, and it's something that you should be aware of before you're filing so that you can get that evaluation and have it ready to go.
Another thing that comes up is that I want to change the status from H4 to F1 or H1 to F1. Previously, it used to take only 2 to 3 months for the people to get their F1 status adjudicated. Nowadays, it's taking approximately anywhere between 8 months to 19 months to get the F1 status adjudicated. The minus point here is, unlike the other change of status from other statuses to the non-immigrant status, for the F1 status, if you're trying to change until the F1 status is approved, 30 days before the approval of the F1 status to be exact, but for your calculation purposes, until the F1 status is approved, you have to maintain some other status. So if your H4 is expiring in December of 2018, you're filing an F1 status. If your F1 is not getting adjudicated by January, you need to file a H4 extension. In some cases where if you're not eligible for the H4 extension, you have to file another bridge application for B2 application. We have done in some of the cases not just the B2, because B2 we only file for 6 months, F1 is still not adjudicated. We file an extension for the bridge application for B2. Still the F1 is not adjudicated. Then we file the second extension for the bridge application of B2, and B2 extension, B2 second extension, and F1 has been adjudicated at the same time. And the client has gone through agony in those 18 months. For those people who are actually aging out on H4, the children who came here on H4 who are becoming 21, you may want to file the application way early, probably when you are in 19. And for those people who are in H4, please be, or any other status, please be careful that you have to maintain the status until the F1 is approved. Certain times, maybe it's worth for you to go outside the country and get the stamping and come back. But I would like you to discuss one-on-one with a lawyer to see if that option is viable for you. There are some technical problems, especially if you have an I-140 pending or any of the I-140s filed. You might want to discuss one-on-one. There are risks involved in going outside the consulate and getting stamping. There are risks involved in filing the F1 status in the United States too.
All right. AJ is asking about EB3. It's moving for India. It's moved quite a bit, whereas EB2 is sitting still right now. Do you think EB2 might move forward at all?
Right now, I think so. The gap is only 2 to 3 months between EB3 and EB2. I'm expecting, because a lot of people are in EB2 right now, EB3 might inch a little bit forward than that of EB2 up. There's another reason why I think so that EB3 is going to move forward, Emily. Because EB3 has priority tests have never come to this stage of 2009. EB2 has gotten to 2010, and there are a lot of applications pending in EB2 already in adjustment of status. How many applications are pending? Approximately about 15,000 applications are pending in adjustment of status right now. So since there are no applications pending, not much application pending in EB3, there is a chance that EB3 might inch a little bit forward than that of EB2. The reason why EB2 is not going forward is that previously all the unused EB1s and all the unused EB2s used to be given to, have been given to the countries that are using the most, which happens to be India. But now, since EB2 and EB1 is getting filled out mostly by other countries, very less is left for Indians. I'm expecting EB3 to be moving forward. However, the good news is that if you have an EB2 already approved, there are ways that you can convert the EB3 to EB2 without filing another labor certification, which most of the audiences know that it's going to take a long time to file the labor certification. Now, even though you have used the labor certification to get the EB2 approval previously, you could use the same labor certification for filing another EB3 I-140 immediately. You may want to discuss with your lawyer whether it's worth for you at this point of time to file the EB3 with the same labor that you have done previously.
Do you think now is a good time to do that, or still too early? Since the EB3 application can be, EB3 I-140 application can be filed anytime, Emily. When the dates inch up, and if you so happen that you fall into that date, I would file the EB3 application along with the adjustment of status on the same day. Right now, most of the people whose priority date is until May of 2010 in EB2, they already filed their adjustment of status. Very less people are there whose priority date is before May of 2010. So I want to do it if I ever fall into the category where my priority date happens to be current in EB3 and not in EB2. At that instant itself, I would be willing to file an I-140 and adjustment of status at the same time. So whenever the priority date becomes current for EB3, even though I am in EB2, I will at that point of time file. I won't do in advance, but I will do it when the priority date becomes current. All right, so Ankar has a question. If the I-94 expires while the H-1B extension is in process, is there a chance of getting an NTA?
Chance. It's always a chance, right? It's one is that the H-1B has to be denied. You're not going to get just NTA unless your H-1B extension gets denied. Yes, there is a chance that NTA might be issued, but as Emily has pointed out before, we haven't noticed the NTA at this point of time. I don't want you to run away from this country. Mm-hmm. If I were you, I would not. I would wait for it. But yes, there is always a chance. I mean, especially with this new memo, there is a chance. Please tune in to our Facebook and YouTube and all other things. ImmigrationGirl.com. You subscribe and go to RN Law Group. We have a daily conference call. People were asking when it is. It's there in our website at www.rnlawgroup.com. You can get the more information. At this point of time, I would not panic and leave. But to answer your question, is there a chance? Yeah, there is a chance.
Yeah, and I just want to remind everybody that you can avoid that risk by planning ahead, filing early, filing in premium processing, and getting the decision before your I-94 expires. There's no reason to wait until the last minute to file your extension. There's no reason to file it 5 months in advance in regular processing when processing times are 8 to 10 months. File it in premium processing well in advance. Spend the extra money, spend the time to put together a solid application, and you'll be fine.
Srinivas has a question. Is there any lawsuit that is getting filed on August 9th memo? Our office is working with a lot of different organizations. We already just approved the STEM extension, part of it, third-party placement litigation has been filed. We're working. We cannot file a litigation on a memo that doesn't exist as of now. And that is just a proposal at this point of time, August 9th memo. Although we know that most probably they might make it final. Once they make it final, then we have a chance of litigation. But we are contemplating litigation on the August 9th memo.
So just a review on the July 13th memo. We're going to have to start naming these memos since they come out every week. Everyone's got a new date. So the July 13th memo is the memo on the RFEs, saying that you don't have to issue an RFE. Adjudicators can just flat out deny a case if it's missing required initial evidence. Does that memo apply to H1s?
Yes.
L1s?
Yes.
L2s?
Yes.
H4s?
Everything, please.
E80s? I-140, yes, it applies to I-140, whoever asked that
even
question.
STEM extension.
Yes, I-765. Every single application, you have to file it with the required initial evidence according to the form instructions. So please review the form instructions and according to whatever's mandatory in the statute and the regulations, and make sure everything's there before you file so that you don't end up in that situation. If the application's properly filed, this memo should not hurt you. That's the hope anyways.
I call that as Friday the 13th memo, intent to deny memo. In our office, we're contemplating, it's Friday. We always get bad memos from the USCIS on Friday. And it was Friday the 13th, so we were scared of it, and then this comes out. Not a good thing for all people. Anything else?
I think that's about it for today. So thank you for joining us.
Thank you guys for joining. Again, please subscribe to ImmigrationGirl.com. We would like you, if you would say likes in the Facebook, and please subscribe to our YouTube channel. Thank you again for coming to this live. Thank you guys.